So could you share with us all of the whatever parts you think actually you would like to have admitted and published?
Yes.
I mean, can you do that from now on without me having to beg you to do that?
And we are back, and we are back. Give a thumbs up for being back after a long weekend, y'all. Just go ahead and stop what you're doing and go ahead and hit that thumbs up. We certainly do appreciate it. Y'all, today, what we're going to do, we had Mr. Sprinkle. You know, he's kind of interesting, but kind of boring at the same time. We had him under DA Love's direct, and then we had the cross-examination. Everything that's important that DA Love said or that Sprinkle said in the direct is going to come out in the cross as well. So we're going to skip right to the cross. One thing that you will certainly notice here is the investigation of the Donovan Thomas, and this whole investigation seems to have been done. Not all the T's were not crossed and all the I's were not dotted. You're certainly going to see that. But in addition to that, more late discovery. Just late discovery after late discovery after late discovery. Judge Whitaker is exasperated, but there are no penalties. So, sorry, spoiler alert, more late discovery, but no penalties. And you're going to see that here. You're going to see Judge Page kirk out a little bit, but still nothing's going to happen. So without further ado, not going to talk anymore. We'll jump right into it. Thanks for watching. Don't forget to like, comment, subscribe, and let's get into it.
Confirmed, though Mr. Zachary was able to confirm some information about his phone number, another phone number. I told her that I don't expect to keep her very long. I don't expect her to be more than today, frankly. And yeah, that's it. And the other matter that I wanted to broach with the court simply dealt with the concerns that the court had that we broached briefly regarding some of the cross-examination testimony and some of the information in the interview with Mr. Zachary on the 5th of August, 2015, that we believe has addressed some of the concerns that the court had regarding.
I'm sorry, but I don't know what you're talking about.
So in my email to the court, I said that there were some matters that we would ask permission to address prior to playing the interview. Some of the portions of the interview that defense requested redacted, the court said that it needed sometimes foundational information before I went ahead and.
Okay, and I think that Ms. Persfield responded to everybody that we're not going to address that this morning before, and we know that the jury is going to be here and ready to go at 9, and I don't think there's going to be time to address all of that in the 5 minutes before the jury is here. Do you?
Well, there is one that I think we can. It's the first one that we have listed.
Okay, well, anyway, that is what I said we would address either at lunch or at the end of the day, correct? All right, and so for that reason as well, we're not really ready for Detective Gaither's testimony. So go ahead and call Mr. Sprinkle over and let's pick up with him, because we can't, if we need to do the whatever is or is not going to come in the interviews and it's different from what we had already made determination about, and we left some things for determination. We have to figure that out during the lunch break. So,
yes, Your Honor. Will the court permit me to step out and make that phone call?
Yes, please.
And also, Your Honor, so will the court be permitting me or allow me to bring Mr. Sprinkle back after we get in the testimony?
I mean, it seems to me like that's been kind of the way this case has gone, is that people get called back 2 and 3 times. So sure, you can do that with him too.
Mr. Sprinkle, good morning, sir.
Good morning. How are you?
Doing well, doing well. All right, as I understand it, and you and I have met before, is that true?
Yes.
All right. You are a deputy district attorney with the Fulton County District Attorney's Office.
I am.
You have been so employed, as you've indicated in your testimony, for since 2013. Does that sound about right?
2011.
2011. Okay. One of the things that you talked about initially, I think your testimony perhaps when you were here last, was your specific role in regards to reviewing case files.
Yes.
Recall that. I heard you say, and you tell me if this is accurate, that sometimes when a file comes to you from an investigating agency, that it is not always, in your words, complete.
Yes.
And you testified, did you not, that it would be your job or your duty, your responsibility to do some additional work. That may not be the word you use. You may have said investigation. I'm not sure.
I understand. Yes. If it's not complete insofar as we don't believe that it would be appropriate to present it to a grand jury and subsequently a trial.
Right. Because, of course, your interest as an assistant district attorney is to make sure that cases are properly put before the court or put before a jury. True?
Correct.
And in fact, when you, one of your duties as a district attorney is to make sure that there is sufficient evidence or appropriate evidence presented in a case that goes before a court, goes before a jury. Correct?
Yes.
All right. Because it is important to make sure that people who need to be prosecuted are prosecuted, right?
Yes.
It is important to make sure that people who should not be prosecuted are not prosecuted.
That's correct.
You do not want, and your duty, I believe, encompasses this, you do not want to have someone charged or arrested or their freedom taken for an offense that they did not commit. True?
Overruled.
Is that true?
That's true.
Okay. And so I want to talk to you about a number of things, but I want to start by asking if I'm correct that when you came into this case in 2016, the case had already been with detectives Gaither, Dennis, and Thorpe, right?
That's correct. Those were the detectives that primarily were the ones that I knew of that had been working on it. Yes.
Work had already been done on the case as far as you knew.
Yes.
In fact, people had already been arrested in this case.
Yes.
And I'm talking specifically about Donovan Thomas's murder.
That's right.
All right. Because that's what you were looking at.
That's right.
And so you knew by the time that you came into this that there were 4 people who were sitting in the Fulton County Jail who had been charged by the detectives whose name we've just referenced with the murder of Donovan Thomas.
That's
You know
correct.
that. Kenneth Copeland, Shannon Stillwell. Who else?
Antonio Sledge and Demiki and Garlington.
All right. Those people, as far as you knew when you picked up this file, had already been investigated by the detectives, true?
That's true.
And by the way, you had worked previously. I mean, you knew who detectives Gaither, Dennis, and Thorpe were. You know who they were.
Yeah, I knew who they were. Yes.
You'd worked with them previously.
I had.
Right. And so you came into this with people arrested, believing that the work had been done properly to have these 4 folks in the Fulton County Jail, right?
Well, that was my hope.
Right, right. That turned out not to be the case, right?
Correct.
In fact, tell me if this is right. I think you testified to this, that there was the interview of this gentleman named Spencer Wright in, what was it, October the 19th of 2015?
That sounds right. Yes.
All right. And that
2015. Did you say 2015?
2015.
Yes. Yes.
Okay. And that interview was done by Detective Thorpe, correct?
Correct.
And the next day, the 20th, is when Detective Thorpe went in front of a judge and got an arrest warrant for the 4 people whose names we've just mentioned.
Yes. Yes, that's correct.
All right. And those 4 people were arrested and put in jail as a result of the investigative work that had been done by those detectives whose names we've just referenced.
Well, when you say those detectives, I would not, Detectives Gaither and Dennis, I wouldn't group them into that. It was Detective Thorpe that was the affiant on the arrest warrants for for Mr. Sledge, Mr. Garlington, Mr. Copeland, and Mr. Jackson, aka Mr. Stillwell.
Right. So one person swore out the warrant. That was Detective Thorpe, right?
That's correct.
But you're certainly aware that over the course of the investigation from January of 2015 to the time that Thorpe went and took out that arrest warrant in October of 2015, that he had communication and collaboration with Detectives Dennis and Detective Gaither. You know that, right?
Well, he sat in on interviews with them. Some of these interviews that we've discussed or I discussed on direct. So, yeah, and they work for the same agency. So, yes, I would say yes.
All right. And looking at your, what you've termed, maybe we've termed the Sprinkle Report, right, where you kind of reviewed this case, looking at that report, you know that there were times when, for example, Thorpe would go and consult with either Gaither or Dennis about a particular individual that they were investigating. True?
I don't. It would seem like it would seem that would be the common sense thing that would have happened. And I'm not trying to be difficult, but I don't know what kind of I don't know what kind of conversations Detective Thorpe had with Detective Gaither and or Detective Dennis.
Okay. Well, here's a for instance. You know that there were interviews of Kenneth Copeland where Thorpe, Gaither, and Dennis were all present.
Yes.
Right? And in fact, what was it, 9-10 hours worth of interviews of Kenneth Copeland?
There was one interview that was over 9 hours long. So, and there were multiple interviews with him. So it was over 9 hours. It suffices to say.
Right. So getting back to my, the question I asked a little while ago, you certainly had information that these three detectives, Thorpe may have been the one who took out the warrant, right?
Yes.
But these three detectives were in contact, in communication with each other in regards to Donovan Thomas's murder. You knew that.
Yes.
Right. And ultimately, what happened is that they arrested the wrong people, didn't they?
As to vagueness and the word they.
Okay. Ultimately, the Detective Thorpe with the Atlanta Police Department, after consulting or talking to Gaither and Dennis, took out for these four individuals, charged the wrong people with the murder of Donovan Thomas, correct?
To that question, Your Honor.
Sustained.
When you, one of the things that you did when you first began to kind of look into what had happened in this matter is that you realized, and you said this in your report, if I'm wrong, maybe I'm reading it wrong, you correct me, okay?
Okay.
But one of the things that you said in your report is that it seemed as though the arrest of these individuals, and by the way, these folks were arrested. I mean, they weren't just like suspected. They were actually put in jail, right?
We got that.
Okay.
Go ahead and ask your question.
All right, get in there. You said that this was almost entirely based on the statement of Mr. Spencer Wright.
Yes.
Right?
Yes.
Okay. And it turned out that Detective Thorpe, or whoever else was involved, did a ridiculously poor job of vetting or looking into Spencer Wright's statement. Isn't that true?
Well, there was surveillance video that Mr. Wright said he was a specific place, and there was video that would have showed whether or not he was there. That apparently was not inspected very closely prior to obtaining arrest warrants.
Right. Well, in terms of not investigated fully, Spencer Wright, Thorpe spoke to Spencer Wright on the 19th of October, right?
Yes.
Now, when you came into the case, one of the first things that you thought to do was to really examine the statement from Mr. Wright. Is that true?
Yes.
And you did so?
I did.
And you spoke to him?
I did.
One of the second or third things that you did, right, just using some common sense, was to go and look for video around the location where you thought Spencer Wright would have been, right?
That's right.
And you did that.
I did.
And you were able to find it.
I was.
And it was pretty easy.
It was.
Detective Thorpe, before arresting folks based on your words, almost entirely the statement of Spencer Wright, never took the time to even go look for video where Spencer Wright supposedly would have been, did he?
Well, that I don't know. You would have to ask Detective Thorpe that.
Well, did you? Did you ask Detective Thorpe that?
Oh. I'm sure I did.
Let me guess. The answer was that he had not done it, right?
I remember the answer he gave at the preliminary hearing about the video.
Okay. Well, let me ask you this. When you come into the case in 2016, was there any video that had been procured from that location by Detective Thorpe? Where the bus stop, where Spencer Wright
Yes.
would have been?
Yes.
Was there?
There was a video camera, and in the viewable area of that camera was the bus stop where Mr. Wright said that he was standing at the time of the homicide.
Right. Had anyone gotten that video?
Yes.
Who did?
It was the specific investigator was probably either Frederick Page or Jason Teague, but
Okay.
ultimately it wound up in the possession of Detective Thorpe.
Okay. Before these four individuals were arrested or after?
Before.
Okay. And so even having the videotape that you looked at
Mhm.
and that you made a determination was pivotal in the arrest or in the case, even having that information, Detective Thorpe still went ahead and swore out the warrant for the wrong people on October the 20th?
That's right.
So after you realized that Thorpe had not done what should have been done in the case, right? You went a little bit further and you got some recorded phone calls of Spencer Wright, true?
I did.
And you were able to listen to those calls. And I'm not asking you what was said, but the contents of those calls, you were able to listen to those, right?
I did.
And those were also instrumental in convincing you that here we are in 2016, that the wrong decision had been made by the detective, right?
That's correct.
Okay. And so would I be correct, sir, that you then, realizing as an assistant district attorney charged with the duties that we've just talked about, used all deliberate speed at that point and said, you know what? Detectives messed it up, got the wrong people in jail. We got to get them out of jail right now.
Yeah, well, I disclosed all of this to the defense attorneys at the time. I can't remember if Antonio Sledge got out of jail pretty quick because that case was just thrown out at the preliminary hearing.
Mm-hmm.
The other ones, I would have to review the record. I know that, well, I'll just leave it at that. If they were in jail, I don't know if it was just on this or other things. I just don't know.
Okay. Did you do, what do you call it down here in Fulton? Is it an NPGJ, not presented to the grand jury when you dismiss a case?
Yeah, it's a form. It's I don't know what I don't remember what it basically says. We're not presenting the case. The evidence is not sufficient. We're not presenting. That is, the DA's office is not presenting the case to the grand jury at this time.
Okay. And so when you realized what had happened in this case, did you file such a form?
Well, so that would have been the elected DA at the time, Paul Howard, that would have authorized or maybe have even signed that himself. But Kenneth Copeland, well, no, I believe that was done with Kenneth Copeland.
Mm-hmm. When?
I don't recall the date.
Does 2017 sound about right?
Yes,
okay.
It does. I don't that again. I don't recall the exact date, but that does sound about right. Mr. Sledge, his was thrown out like January of 2016, I believe, whenever the preliminary hearing was.
Mm-hmm.
And as far as Garlington and Mr. Jackson, aka Mr. Stillwell's, was never thrown out. And as for Mr. Garlington, I don't know. I don't know if there was an MPGJ filed on him or not. There should have been.
Okay. As you're reviewing the evidence in the case, and we've just talked about Spencer writing that information. You talked earlier and you were asked questions about this other video that you looked for. Remember that?
I did.
And you remember a little while ago you were asked questions about video from the Texaco gas station.
Yes.
Okay. You remember, and I think you testified that there was this video that you received or that you were able to review of vehicles at the Texaco gas station not far from the barbershop around the time that the incident occurred, right?
That's correct.
You talked earlier, if I'm right, about this Pontiac Bonneville, right?
That's correct.
You talked about other vehicles that you saw, correct?
Correct.
You talked about individuals that you saw there at the at that gas station, right?
That's correct.
You were asked by the prosecutor whether you saw Kenneth Copeland on any of those videos. Remember that question?
I do remember it.
Your answer was no,
That's right.
because you did not see Kenneth Copeland at that gas station, that Texaco, sometime around the time that the murder occurred, right?
That's correct.
Right. You weren't asked, so I'm going to ask you whether you saw Jeffrey Williams on that video at the Texaco at around the time that the murder occurred. Did
Okay.
you?
No, I didn't see Jeffrey Williams on there. No,
And you looked at the entirety of the video, right?
I did.
I think I heard you say that on all, I don't know if you said all of them, a lot of videos, you went back and you looked at them multiple times, right?
Mm-hmm.
So January 10th, 2015, somewhere between, let's say, 6-something and 6:50 and 7:30, the time that you looked at the Texaco, Jeffrey Williams is not on any video getting out of any car, getting into any car at the Texaco down the street from the barbershop. True?
That's true.
I heard you say that one of the things that interested you when you looked at that video at the Texaco is that you saw an Infinity. Remember saying that?
Yes.
Okay. And you became interested in doing some additional research or investigation on that Infinity vehicle. You remember that?
I do, but actually, I think that if we're talking about when I decided to do certain things, I may have actually conducted additional research on the Infinity before it caught my attention on the Texaco footage. I can't remember the exact, but just to be precise, yeah, I mean, it was probably around that time, but yeah.
But one of the things that we know for a fact is that you determined that you wanted to get more information about this rental vehicle, right?
Yes, that's right.
And you did. You and or your investigator made contact with the folks at Hertz, right?
It started with me when I sent the subpoena to Hertz. And then after that, after receiving some documents from a woman named Carolyn Fry, then I asked David White to travel to the location where the vehicle was rented and speak with the staff at that location.
Okay. So let me ask you some very specific questions about any information that you gleaned about that rental vehicle. You testified earlier that one of the things you were able to determine is that the vehicle was rented in the name of Jeffrey Williams. Is that what you said?
Yes.
Right. You were not able to determine who it was that actually rented the vehicle, just that it was in the name of Jeffrey Williams. Isn't that right?
It was in the name of Jeffrey Williams, his driver's license number, and a signature. There's a signature as well.
Now, tell me the date that vehicle was rented.
From what I remember, January 7th, 2015.
All right. So that would have been 3 days before January 10th of 2015, correct?
That's right.
All right. Now, tell me, if you can, who had possession of that vehicle on January the 8th of 2010?
2015?
2010? 2015, yes.
Yes. I don't know.
You don't know who had possession of that vehicle on January the 9th of 2015?
I do not know.
And you certainly don't know who had possession of the vehicle, no personal knowledge of who had possession of that vehicle on January the 10th, 2015.
If we're talking about actual possession, the
Actual
person,
possession.
then no, I do not know.
Okay. You never strike that. By the time you came into this case, that rental vehicle, I mean, it had been at this point, what, a year since the incident? We're talking January 2016 is when you're in this case?
Yes, I obtained the records from Hertz in 2016. It would have been over a year. I've been around April of 2016 when I obtained the records from Hertz.
I want to ask you about some of the things you did not do. Okay.
Okay.
You referenced earlier there were a lot of numbers being phone numbers being kind of, I don't want to say thrown at you, but put in front of you in terms of, well, you were able to get information on this phone number and that phone number, the frequency of communication. You remember those questions?
I do.
And you did in fact have the ability to procure phone records by way of either subpoena or search warrant or court order.
That's correct.
Okay. You were able to get a lot of different phone numbers on people that you thought or individuals you thought might have been of some interest in the case. Is that fair?
That's fair.
Okay. You also, when you request those phone records, you have the ability to request cell site or cell tower information, correct?
That's correct.
Now, and I know you're not an expert, but you are familiar with utilizing, maybe with an expert, cell site and cell tower information to try and make a determination as to where someone might have, or where a phone might have been at a particular time. True?
Yeah, I'm pretty familiar with plotting cell phone records. I'm not like an FBI CAS team member or anything like that, but I can hold my own.
Right. So having listened to Kenneth Copeland's statements, and you did that, all right? Mm-hmm. Having listened to his statements, one of the things that you would have wanted to do, I presume, I'm asking, is try and determine whether or not you could corroborate certain information in his statement. Is that about right?
That's about right.
All right. He gave, like we said, at least one 9-hour statement, and he gave a lot of statements. There was a lot to listen to from Kenneth Copeland.
Yes.
Right. And he gave information that you would have used to follow up in your investigation.
That's correct.
All right. The name Demekian Garlington came up in your investigation. Is that right?
Yes.
Right. There was this reference in listening to Kenneth Copeland's statements. There was this reference to a conversation, phone calls that he would have had with Garlington, right?
That's correct.
And it would have been some interest to you to figure out whether or not what Kenneth Copeland was saying, not just about that, but everything was corroboratable, was true.
Yes.
Right? Or whether Kenneth Copeland was lying to y'all, lying to the detectives, not y'all, because he had already been interviewed, right?
Right. That's right.
Because you considered him to be a pivotal witness in the case.
Yes.
Right. And some of the things that he said, you would have considered to be pivotal things that you wanted to follow up on, right?
Yes.
And if you have a witness, just like Spencer Wright, for example, if you have a witness who you think has pivotal information, but that witness is proven to be a liar, that's something that you want to know in regards to the investigation. True?
That's true.
And one of the things you could have done in regards to Kenneth Copeland and any statements he said, phone calls he said he may have had with someone named Demekian Garlington, is you could have gotten Garlington's phone records to determine whether or not those communications took place, right?
That is correct.
And also where Mr. Garlington was to see whether that comports with what Kenneth Copeland said, right?
That is correct.
Now, you got Kenneth Copeland's information, his phone information, right?
I did.
You got his location, so you knew, or at least the phone, where that phone was at certain times on the night of January 10th, 2015, right?
Well, to be specific, what you see with tower data is the tower and the side of the tower that the phone utilized. That can be a pretty large area. In a city with a lot of cell phone towers everywhere, you get a little bit of a better idea, but I just want to make sure that we're clear that it's not the exact location of the phone.
Sure. Not the exact, you can't pinpoint within feet or maybe not even within a block, but it was important enough to you to get that information on Kenneth Copeland on the phone that you thought was being used by Kenneth Copeland, right?
Yes.
Now, you did reach out to get information on Garlington's phone, or what you thought was Garlington's phone, right?
There was a number that I thought may have been Garlington's number.
Sure.
And I believe I referenced that in my report. And if correct me if I'm wrong, I believe it was maybe a Sprint number, or maybe I can't remember exactly. It wasn't in his name. I was never the short answer to your question is I was never able to get tower data for Demeke and Garlington.
Well, it's not that you weren't able to get tower data. You requested the data for that phone number and specifically requested it without the tower usage logs. Isn't that right?
Yes. So there was a number that was in Kenneth Copeland's records, came back, I want to say to a female. Now, and I remember, and this is, I'm thinking, and unless there's something that can refresh my recollection, from what I remember, I couldn't prove. It's one thing to get call logs are very easy to get. You don't need probable cause for those. But to get location data, you need probable cause. And I remember, from what I recall, I didn't think that I had probable cause to get tower location data for this number. Usually I'll try to do something like, there's a number of things. Like if I find a jail call to the number and I hear the voice that picks up, I say, oh, well, that corroborates that number is in fact that person's number. Or if somebody cites it on their Instagram page and says, call me on this number, that's going to get me to probable cause that that's that number. But if it's just that it's in temporal proximity. And I think there was another issue with the retention period of the number. I don't, all I know is I didn't think I had probable cause. I never got probable cause to get the tower records.
Let's work backwards a little bit, right? Let's start with this. When you sent out the request for the records that you thought was a number to Demeke and Garlington.
Yes.
You requested those records specifically without tower usage logs, right?
I did.
Okay. Now, you had previously requested records for what you thought was Kenneth Copeland's phone number with the tower usage logs, right?
I don't know that it was me that did that. It may have been investigator or detective Dennis that did that.
Right. But one thing that you knew, I mean, you honed in on the fact that there was supposedly this call between Kenneth Copeland and Demeke and Garlington, and they were supposed to be at a specific place on the night of January 10th, 2015. Isn't that right?
That's correct.
Right. And so you had listened to Kenneth Copeland's statements, and you knew from Copeland's statements that he made reference to Wade Garlington, who was an important witness to you, right?
It was.
Right. You knew that Copeland had made reference in his hours of statement about this conversation and the location of Garlington, who was an important witness. You knew that.
That's right.
Right. And so you still didn't think that that was enough for you to go ahead and try to verify whether Kenneth Copeland was lying through his teeth or not by getting Garlington's tower usage logs.
I will say one other thing.
Your Honor, may we approach?
All right, Mrs. Sprinkle. So I'll just ask the question just very simply. Bottom line is, I am correct when I say that you requested the information on Mr. Garlington's phone, but you requested those without the tower usage logs. Is that true?
That's right.
Okay. I want to ask you something about a picture that we looked at a little bit earlier. All right. Remember the picture that the state put up? I think it was States 510 and DS 44. You have those in front of you?
I do.
Do you mind if I step up and take a quick look at them? May I, Judge? All right. May I, Mr. Sprinkle? I wasn't clear earlier, so I want to see if I can clear this up. You've been to what's been termed the Sky House, right?
That's correct.
As in, you have been there to the building, right?
That's correct.
Have you been inside to the individual units in there?
I have not.
So you've not stood inside of the Sky House in front of a window and looked out the window to observe what the skyline that you can see or what the view is you can see from a particular window, right?
That's correct.
Okay. And so those pictures that you saw earlier, you've seen the pictures before, right?
I have.
But you have not stood in the vantage point of the person in that picture to be able to say, this is someone looking out the window of the Sky House.
That's right. I have not.
The bulk of the work that you did was in regards to the January 10, 2015 shooting of Donovan Thomas. Am I correct about that?
That is correct.
Okay. You were asked a couple of questions about some other matters. Specifically, you were asked some questions about this Lil Wayne tour bus shooting business. Is that right?
That's right.
Right. Would I be correct in saying that what you know about that is information that you received from Detective Raisi and any other detectives or investigators involved in the case?
Yes, Detective Raissi, David Racy. He, last I heard, was with the ATF.
Okay. You spoke to him and you got some information from him, correct?
I did.
You were not intimately involved in that, any investigation of that portion at all. True?
That's true.
You were asked a question earlier though about a phone number.
I was.
The prosecutor asked you about a 770-881-1440 phone number. Remember that?
I do.
Okay. That is a phone number that you looked at while you were looking at this whole Lil Wayne tour bus business. True?
I don't know if that, I don't know if that number caught my attention because of the Lil Wayne tour bus
Okay.
incident.
Do you know who Clifford Harris is?
Yes.
T.I.?
Yeah.
Okay. That's his number, ain't it?
Yes, that's what I found. That I
Okay.
concluded, yes.
And if I heard you correctly, that's a phone call to that number that may have been picked up, may not have been picked up, but ultimately doesn't have any significance to you in regards to this investigation. True?
I mean, just that it was an incoming call at 7:30 p.m. on January 10th, 2015.
That's it.
That's right.
Okay. Oh, you know what? Let me jump back a little bit, if you don't mind, to the whole Sky House business. You one of the things you were asked was whether or not there is controlled access at the Sky House. You remember that question?
I do.
Your answer ultimately was yes, right?
That's correct.
But the truth is, you referenced that there was what you believe to be a call box at that location.
That's right. There was a call box, a number that I identified. I just can't recall. There's obviously going to be controlled access.
Why do you say obviously?
Well, I mean, to get into the individual units, and there was a call box for which I identified a number. I just don't recall where the controlled access point was. Like, do you need one to get into the parking garage? Do you need one to get into the building? I just don't remember. From my personally going out there, I just don't remember.
Sure, and that's really what I want you to testify to, your personal knowledge.
Mm-hmm.
The truth is, you don't have any recollection as to whether or not there's any particular way to get in a gate, or whether there is a gate that you have to get buzzed in or anything like that. You don't know that, do you?
That I don't remember. I don't know if it's like the building, the door to the lobby was open, and then from there, or you had to get buzzed up. I just don't remember.
Okay, so the truth is, in talking about the Sky House and the access to the Sky House, you're really not in a position to tell this jury that, yes, there's a controlled access and there's a certain way to get in there. You just don't know.
I just don't remember. Like I said, I'm sure I know that there was some sort of control. I just don't know if it started at like the lobby door or in the parking garage. I just don't know.
Okay. Do you recall, you had an opportunity to listen to statements by various individuals in this case. Now I'm going to hone in on Quindarius Zachary. You had a chance to listen to his statement?
I did.
Okay. And you're aware that Detective Dennis had a conversation with Quindarius Zachary. Is that right?
He and I both, well, there were a couple of them. During one of them, he and I both did.
You sat in, right, on one, but that's not what I'm getting at. I'm asking whether or not you had an opportunity to listen to any statements between Mr. Zachary and Dennis prior to your involvement in the case.
Yes.
Okay. Judge, may I have one moment, please? You obtained records for numbers that you believe belong to Jeffrey Williams. Is that right? And I'm talking now, I want to hone in, right? I'm speaking specifically in January of 2015.
That's right.
Okay. You obtained numbers that you believe belong to Jeffrey Williams.
Yes.
Okay. You obviously, as we've discussed before, obtained numbers that you believe belong to Kenneth Copeland.
Yes. Kenneth Copeland, I believe that was somebody else, but when you say you obtain, I'm speaking, what I'm saying is I reviewed records. So either I or a DA's office investigator obtained them, or some law enforcement investigator obtained them, or if I obtained them via subpoena, et cetera.
Sure. And I don't, and listen, feel free to correct me if I'm wrong. And when I'm saying you obtained, I'll tailor it. You had a chance to review.
Yes.
Okay. You had a chance to review phone records that you believe belong to, as we talked about before, Mr. Demikian Garlington. Is that right?
There were records for Demikian Garlington. Yes, but they didn't cover the night of the murder. But yeah, yes, there was also, and I think we talked about this already, a number that I found in Mr. Copeland's phone records that I believe was Demikian Garlington's, but I never got to probable cause.
So here's my question, right? Focusing now on Jeffrey Williams, the number you believe belonged to Jeffrey Williams.
There were a few.
And Kenneth Copeland, all right?
Okay.
There are, and I'm talking now about the night of the murder, January 10, 2015. There are 0 calls. I mean, 0 as in nothing, none, zilch. 0 calls between Kenneth Copeland and Jeffrey Williams. Isn't that true?
That sounds correct to me. There's the phone records can be voluminous. So I'm going off of, my memory from, I feel like I would have remembered something like that. I'm also refreshing my recollection by looking at my report from the excerpts I placed in the report. And and specifically, I included Kenneth Copeland's phone records, the relevant portion from the night of the murder. And matter of fact, I'm looking at it right now. Yes, there are no phone calls to Jeffrey Williams.
Okay. What about phone calls between Demikian Garlington and Jeffrey Williams?
No, I don't believe so either. No.
0 phone calls.
That's right.
Wiretaps. Did you have the ability to seek any wiretaps in this case?
No. We certainly had the ability to seek it, but we never did.
Okay. And I'm talking specifically, and you said we, but I'm speaking specifically now about Jeffrey Williams. No wiretap of any phone. You never sought any wiretap of Jeffrey Williams' phone, did you?
No, we never did.
So we've talked about what you've done in regards to the Donovan Thomas matter. We've talked about this tour bus shooting thing that you didn't really have anything to do with. I do want to jump back and ask you a question on a name that you mentioned earlier. Sammy Davis.
Okay.
Okay. Sammy Davis was someone that you spoke to.
He was.
Okay. That was someone who was supposedly at the location or somewhere close to the location on the when the incident occurred. I'm talking about January 10, 2015, correct?
That is correct.
Okay. And you had a conversation with him in 2016?
I believe it was 2017.
2017. Okay. Without saying what that person said, actually, strike that. You mentioned earlier, Mr. Sprinkle, Twitter records that you were able to, and I guess it's called X now, but Twitter records you were able to retrieve in regards to individuals in this case, or that you looked at. True?
That is correct.
Did I hear you say that you reviewed Jeffrey Williams's Twitter records and Twitter history?
I was aware that Mr. Williams had a Twitter page. I don't recall how closely I examined his Twitter page, though.
Okay. So you would not be in a position to tell this jury that there's anything about his Twitter page that you reviewed in regards to January 10th of 2015?
Well, if I did, it's not something that made an imprint on me such that I remember it. So I would say no, there was nothing.
Right. And because you are charged with reviewing and making determinations about what you think is important or pivotal in the case, if there was something there, that would certainly stick out in your mind.
Yes.
And it does not.
That's right.
I may have one moment, Judge. I may be, give me one moment, please. I wanted to jump back to, remember we talked a little while ago about Mr. Copeland giving a statement about a conversation between he and Garlington the night of the incident?
Yes.
Okay. You recall from listening to Copeland's statement that he references that the night of the incident, he's supposedly at the McDonald's and he makes a phone call to Garlington, right?
Yeah. That's right.
And you recall from his statement that Copeland also says that he ended up in a vehicle with Garlington and McMullen. You remember that?
I do.
Okay. Now, looking back again at judging the veracity of the statements people give to you, specifically now Copeland, you were able to determine that at the time when Copeland says that he is in a car with Garlington, that Garlington's phone, or the phone you think is Garlington's phone, is actually calling Copeland's phone at that time. You remember that?
No, I'm not sure. You must be referencing Mr. Copeland's cell phone call data records, and there's a phone call at a specific time that somehow occurs at a time when I don't know. Is that what you're talking about?
That is. Let me see if I can break it down anymore. Copeland gives a statement saying that he spoke to Garlington on the night of the incident, right?
Yes.
Copeland gives a statement saying that at some point he's in a vehicle with Mr. Garlington and Mr. Demise McMullen. True?
That is correct.
All right. Looking at the phone records, right, at the time when Copeland says he is in a car with McMullen and Garlington, you actually see phone calls between Garlington's number and Copeland's number when they're supposedly in a car with each other, right?
Well, so first of all, what number are we talking? Would you like me to say which number I believe may have been Demeke and Garlington's?
Sure. Go ahead and tell me what number you're talking about.
It was 404-621-0102. That would have been the pretty much the only number during that immediate aftermath of the homicide with which he was in contact. And there were routed calls. Well, I won't get into that, but I had some what I believe to be limited tower location data for that 404-621-0102. But the calls, there was an inbound call where that Naisha 404-621-0102 rather 621-0102 called Kenneth Copeland at 7:51 p.m. and 36 seconds on January 10th, 2015.
Right.
Now you'll see. Now again, if in fact that was Mr. Garlington's number, there were some routed calls that were between, but a routed call is not necessarily a communication between the two numbers. It could be a call, an attempted call that wasn't completed. So, but as you would have to ask Mr. Copeland, about those phone calls and where he was, and if Mr. Garlington was actually in the car with him, or he was inside, the convenience store or the McDonald's or wherever it was they said they were. I don't know. I just don't know.
Well, okay. Let me ask you if you know this. All right. Again, we agree that according to Copeland, he, McMullen, and Garlington are in a car together, right?
That's what Mr. Copeland said. Yes.
Okay. And there is a phone call. Let's not talk about Copeland. Let's talk about Garlington and McMullen.
Mm-hmm.
There is a phone call between Garlington's phone. That's the one that you've referenced, the 0102, right?
That's right.
What you believe is Garlington's phone, right?
Is that yes?
And there is a phone call that connects between Garlington and McMullen's phone at the time when they're supposedly in the car together, according to Copeland.
That, again, I don't know where they, I know that they were in close temporal proximity, or spatial proximity, I should say, at the time of these, according to Mr. Copeland. As to whether they were actually in the immediate confined space and they hadn't parted ways temporarily and one is calling the other, I don't know. You would have to, again, I don't know if they were within 3 feet of each other at the time of these phone calls. All I know is that they were within 3 feet. They were very close to each other during this time period, at least temporarily, and where they were, if they were walking around a parking lot, I just don't know.
Safe to say that verifying anything that Mr. Copeland says is true proved to be a Herculean task for you, huh?
Well, I just tried to find things that were obviously inconsistent. Like, for example, with Spencer Wright, where I just looked at the video and I saw nobody was at the bus stop. I said, well, that's obviously a pretty big inconsistency in a statement. That's all I was trying to do with Kenneth Copeland. And I didn't, as far as the phone records are concerned, I didn't see anything that was wildly inconsistent or that completely contradicted him at all.
You know, something you said earlier when we were talking about the phones, you said that you're not an expert, but you have pretty significant experience with kind of looking at cell tower locations and if not plotting, at least trying to make a determination, reading those records
Yes,
to determine where a particular phone may have been at a particular time, right?
that's right.
And it's fair to say, again, without asking you for an engineering or technological type answer, that, you know, those records that you look at that give you the distance or location of a phone is not an exact science. It's within miles, right?
It could, I mean, potentially,
Yeah.
it could be in a populated area with a lot of cell phone towers. It'd be very odd to use a tower that's miles away from you. That may be something more in a rural area that you might see. But one thing I will say is no, it's not an exact science.
Yeah. And
Particularly the records at issue here was just, from what I remember, it's just tower usage and sides of the tower.
Right.
Meaning you're using this tower and you're using the antenna pointing this way. That's a big area.
And of course, we're talking about the city of Atlanta, which is very populous.
Mhm.
And we're also talking about things like a call bouncing off of one tower or being routed to another tower because of the traffic, the cell tower, the cell traffic at that time. And the bottom line is that, you know, you could be if you're trying to pinpoint where one phone is at a particular time, you could be a block off, a mile off. It all depends.
Yes,
Sure.
that's true. Yeah.
Okay. All right. I think that's all I have.
The state at about 11:40 this morning sent over what they want to have reconsidered with regard to either agreed upon or ruled upon redactions from Mr. Zachary's interview. And I'm not quite clear exactly what. Are you saying that all of these things were previously either agreed or ruled out as redacted and you want each of them to now be reconsidered? And I don't want to get into the substance. Is that, you sent like several different ones. Is that what it's going to be with regard to each of them?
Some of them, the court said that it needed additional-
Foundation.
Yes.
Okay. All right. And so you think either for those foundation has been laid or we need to take that up now. And then for others, you want reconsideration. Is that right?
That's correct.
Okay. All right. Now I had held a ruling on Mr. Zachary's Twitter feed that was states 526. Are you intending to introduce that such that we would need to take up the various objections that I believe Mr. Adams made, or no?
The Twitter feed, I would be, yes.
Yes. Okay. So is that something that we've not looked at all before now?
What do you mean, Your Honor?
Quindarius Zachary's, I mean, it looked to be pretty thick. That's all of his Twitter posts
It is.
for a
and
certain amount of time.
It is.
Okay. And is that something that the defense has seen previously?
It's been served in discovery.
Okay.
We have not had a chance.
We haven't had like an evidentiary. Okay.
We've not. And if I may just add, we also were not put on notice. The court had requested that they give us the list of the witnesses and the exhibits that are expected to come in through those witnesses. That was not in the list of exhibits for Mrs. Sprinkle's testimony.
Okay. So I mean, this is a voluminous record. Is that fair?
It has 259 pages.
Okay. So I'd call that voluminous. So how are we supposed to just off the cuff deal with what may and may not be admissible in that?
Because I have a set and small number of specific ones that I intended to actually publish. I just wanted him to, I mean, I tendered the whole thing because he got it, but I can distill it down and abide by whatever the court's ruling is.
So could you share with us all of the whatever parts you think actually you would like to have admitted and
Absolutely.
published?
Yes. There,
I mean, can you do that from now on without me having to beg you to do that?
Your Honor, the court does not have to beg me for
Okay,
anything.
I
and
mean,
will-
let's just have it be sort of a standard, which I thought would have been clear anyway, but is apparently not, that you make it clear to everybody what parts of what exhibits you want in evidence so that we can then, if there are evidentiary challenges to them, be able to sensibly discuss those. Is that something you can do for the court and for the opposing counsel in this case?
Absolutely.
Okay. So can you right now let us know so that while we're having our half hour, we can take a look at all of that?
Sure can, Your Honor.
All right. Thank you.
You're welcome.
And the objections, as stated already, generally were hearsay, confrontation clause, and authentication. There's not going to be a confrontation clause issue. People's Twitter posts are not testimonial. But with regard to authentication and hearsay, I don't know if
He can set the foundation, and he can
authenticate these.
I believe that.
Okay,
we can-
maybe. All right. And then there may, okay, so let us know. How are you gonna let us know that? Because can you email to everybody the portions, or how are we gonna?
I can give you the specific page numbers.
Okay, and everybody else has a copy?
Everybody has this. Yes. When you say everybody else has a copy, I'm not sure what the court means.
Of, if you give page numbers, they have a copy so that they'll be able to easily find and look at what that is?
If they scroll, if they look at the
Do
that
you
they
remember?
have.
They have a link. Do you remember which link it is?
Yeah.
Can you let us know that, or at least them know that?
I'll just yes, I can. I can.
Resending it would be great, and then
Okay.
pinpointing.
And perhaps telling us where it is in the discovery.
No, she's going to resend it, which would be easier.
Okay.
Okay, so you will do that and be specific about what parts you want in. All right, Mr. Shart, you had asked in the midst kind of all of the objections that the court give an instruction about the blank box. Is that something that you still want me to do, that the box was blank at the court's instruction because we didn't at that point have anything establishing the date, or?
Yes, I would very much appreciate the court giving
Okay.
that instruction.
And that was
because
states 44, I mean, not states, I'm sorry, Mr. Stillwell 44.
I believe that's correct.
Okay.
I can check. I'll approach and look at the evidence and confirm.
Okay, and so I'll just tell them that it was at the court's direction that the box was blank because it hadn't at the time been established what the box meant.
Your Honor.
Will
may I-
that work? Yes, no?
Yes, that would
Okay.
be great. Thank you.
Yes, ma'am.
Your Honor, that requirement of the court was not on the defendants. They objected to that box being shown. The state had no objection. So in as much as the objection leveled by Mr. Stillwell is what the court based that on, and the state did not have an objection, and the state actually explained what it was, and Mr. Stillwell could have very well put that date in the box.
No, Mr. Stillwell could not have at that point. There was an objection to it. I will give that instruction, and I'm also going to instruct that the state may not in any way attempt to argue that Mr. Stillwell was trying to hide anything by having that box on there blank. Understand? And I'm not saying you would, but just want to make that clear. Understand?
I think, yes, Your Honor.
Okay. All right. I would also, let's see. So we're going to deal with the Twitter feed issues and the reconsideration of Zachary's things. Anything else?
The additional crime scene photos
Your Honor,
from Mr. Atkins.
I don't know if we'll get to that or not. When,
Okay.
when would that be coming in?
Not it.
Your Honor, those probably won't even come in until the next week or the week after
Well, they
next,
may not be
depending.
coming in at all.
Well,
but
if they are to come in, it would be in about 2 weeks from now.
Okay, and it was so like, you said, or somebody said that the CADs with regard to those had already come in. Can y'all be a little more specific about what those are going to be crime scene photos of and why, like what crime scenes and why? I know Miss Love, you said, oh, you put them back because of witnesses that you had to add back in. Can you give me a little more specificity about the?
So at the you want to know the actual
Crime scenes.
Okay.
And then why did you have to add those witnesses back in?
Well, the why was when counsel for
Was it because you were establishing who lived at places and they were gonna object unless you brought the person in?
that was half of it. The other
Okay.
half was that they objected to any of the
Chain of custody, I remember.
right.
Anything
Right.
beyond that?
Yes. So I'm pulling up the actual
Okay.
incident number.
I mean, if you want to just give me an address, like the so-and-so crime
But-
scene.
But these photos, Your Honor, were not produced in discovery.
I
until-
understand.
Okay,
I'm
thank
going to
you.
get to that. I'm just trying to get a little bit of basis for what we're even talking about.
So it was 717 Cedar Avenue. I don't have the date on that in front of me.
Well,
The-
one was 2014, one was 2015, one was 2019, as I understand it. Which was that?
That was 2014.
Okay.
And that was based on an objection about the Nibin hits. And then there was the 807 Pryor and 193 Hendricks shooting, which I think was that was in 2015. That was one of the retaliatory shootings. And then there was the 2019 one regarding Milton Howard in Rayshawn Lucci Bennett's vehicle
Where?
on the road. It was, the specific address was,
This is something there was just testimony about last week. Yes, no?
oh yes, I'm sorry, I thought you.
Okay, well, in any event, you say you added witnesses back because of needing to establish who lived where and the chain of custody, I guess, for like bullets and shells and things like that. But if the photos themselves were never provided, which is what Mr. Adkins represented in his email, then why should they come in now?
Your Honor, so as it relates to the scene, we believe that it's relevant information that does not unfairly prejudice anyone, as the incidents themselves are very much a part of the discovery that we've provided.
But the crime scene photos aren't, right?
Your Honor, I believe I believe that they have not, but I will make certain that they've not. I believe that
Well,
they have
Mr.
not been.
Adkins represented that they hadn't.
And I have no reason not to
Okay,
believe
so
it.
you check on that in our 30 minutes or so that we're going to have, and you can let me know. All right, let's be back here at 1:20.
Your Honor,
Yes.
I know that Mr. Sprinkle had no more questions on direct by the state, so I will put in writing. He mentioned some phone calls, jail calls. The state mentioned with him, but they didn't put him in. I have some objections to portions of those jail calls, and I'll put it in writing for everybody. I just wanted to make the court aware, just in case the state wants to, on redirect, somehow get into those jail calls.
Yeah, are you going to get into the substance of jail calls with Mr. Sprinkle?
Not today, no.
Okay. Ever with Mr. Sprinkle?
At some point, yes, after we get other, yes.
Okay, then yep, go ahead and put those objections in writing.
I'll do it.
And one more thing, Mr. Steele, you sent over an email sort of setting forth an objection or a continuing objection, I guess, that you have to the testimony of Mr. Sprinkle about his investigation, and you base it on Davis versus State, 307 Georgia 746 from 2020, and also Adkins v. State, 301 Georgia 153 from 2017, and the law that's set forth in those about conduct of an investigation, an officer not normally, only in rare instances being relevant, but that it is relevant after, or its case law appears to acknowledge that it can be relevant after a defense has raised questions about an investigation. And yet you're saying at the same time that your co-counsel is asking Mr. Sprinkle questions about his investigation that you don't believe that it is relevant here because the defense hasn't challenged Mr. Sprinkle specifically. And that is, I appreciate that nuance, but my original ruling on that stands. So I'm going to overrule your objection. You may have a continuing objection to that.